Hello everyone, my name is Tan Guan Yu. Together with me are my two other teammates who are Miss Li Doyen and Miss Yo En En. And today we are going to discuss about our criminal law 1 assignment, which is regarding the comparative analysis of events of intoxication in Malaysia and United Kingdom. First of all, what is a defense? When an accused raises a defense, it means that the accused is denying the mens rea element or mental element of him committing a crime. However, they admitted the actus reus, which means that they actually committed a crime but without the mental element, which can make them to be acquitted by the court. Before we begin to our discussion, the most crucial question is why is it United Kingdom instead of the other countries? First and foremost, Malaysia applies the English law under Section 3, 5, and 6 of the Civil Law Act 1956 when there is a lacuna or absence of law under our Malaysian local legislation. In the case of Datin Sri Rosmah against public prosecutor, the court actually applies the English criminal procedure law when there is a lacuna in our criminal procedure code. Besides, our Malaysian legal system and the English legal system are highly likely similar, which we apply the English common law system as well as the Westminster model. Besides, we also like to examine the comparative evaluation of legal framework. As we all know, Indian and Malaysian penal code are pari material. However, sometimes Indian courts also refer to the judgment made by the English courts. For example, in the case of Nita Lanka, the courts refer to the judgment made by English court for the interpretation of evidence under the intoxication law. So, by examining the judgments made by the English courts, we can make a comparative evaluation of the legal framework in Malaysia as well as in UK.
Intoxication law in United Kingdom. Intoxication can impair a person's ability to reason, foresee risk, or exercise sound judgment, which can, in turn, prevent the formation of criminal intent. This issue was highlighted in R against Brady, where the court considered whether an intoxicated defendant could still be held liable for taking an obvious and significant risk. The court ruled that in cases of malice or subjective recklessness, as under Section 20 of the Offences Against the Person Act, the subjective test cannot be made objective simply because the risk was clear to most people. In Brady, the defendant, after consuming alcohol, sat on a low balcony, fell off, and caused severe injuries to the complainant. The court ultimately held that accidents remain accidents even when intoxication plays a role in their occurrence. There are two types of intoxication relevant to the defense, which are firstly, voluntary intoxication and involuntary intoxication. Involuntary intoxication, the principle was firmly established in DPP against Majuski and DPP against Beard. The reasoning behind this distinction lies in the required level of mens rea for specific and basic intent crimes. Specific intent crimes require a higher level of mental intention, whereas basic intent crimes may be satisfied by proof of recklessness. Courts view self-induced intoxication as evidence of recklessness, which can be sufficient to establish liability for basic intent crimes. Below are situations of voluntary intoxication may include, which are willingly consuming alcohol or drugs, secondly, consuming alcohol without realizing its full strength, and thirdly, overconsumption of medically prescribed drugs beyond the recommended dosage. In R against Paul Grog, the court reinforced the principle that a drunken intent is nevertheless an intent, meaning intoxication does not necessarily negate the defendant's liability. Similarly, in R against Lippmann, the defendant, under the influence of LSD, suffocated his girlfriend while hallucinating that she was a snake. While his intoxication prevented the formation of intent for murder, he was still convicted of manslaughter. The court ruled that his voluntary consumption of LSD precluded the use of automatism as a defense. In the recent case of the people, at the suit of the Director of Public Prosecutions against Seelan Eden, the facts are the defendant Seelan Eden stabbed his mother to death in a frenzied attack, inflicting 19 stab wounds. Eden, who had a history of substance abuse, claimed he was in a state of drug-induced psychosis due to prolonged use of drugs, including methamphetamine, which impaired his capacity to form specific intent. Involuntary intoxication, on the other hand, may provide a more robust defense. Courts recognize the defendants who become intoxicated without their knowledge or against their will are less morally blameworthy. Involuntary intoxication can serve as a defense to both basic and specific intent crimes, provided it negates mens rea. In R against Kingston, the Court of Appeal initially ruled that a defendant who formed the mens rea for a crime while involuntarily intoxicated could be excused. However, the House of Lords overruled this decision, holding that involuntary intoxication does not absolve liability if the necessary mens rea is still present. The Lords emphasized that the absence of moral fault does not negate the mental element of an offense. In R against Hardy, this case further clarifies situations of involuntary intoxication, where the defendant consumed soporific or non-dangerous drugs and acted unpredictably. Courts have also recognized involuntary intoxication in cases where the defendant's drink is spiked. They are forced to consume intoxicants, or they mistakenly consume a substance, such as believing it to be aspirin but it is LSD. On recent cases of involuntary intoxication, which is R against William Bradhawk, the facts are the defendant William Bradhawk was involved in an altercation outside a nightclub in Plymouth. The prosecution alleged that after being denied entry, Hawk attempted to stab the head doorman, Muhammad Kondori, causing a minor injury. The incident was captured on CCTV, and additional evidence included statements from witnesses and expert testimony on toxicology. Hawk admitted to being in possession of a knife but claimed he had no intent to cause harm, attributing his actions to involuntary intoxication. A friend had allegedly spiked his drink with JBL without his knowledge, leading to significant confusion and memory loss. The issue in this case was whether involuntary intoxication can be used as a defense to negate the specific intent required for attempted grievous bodily harm. The judgment in this case was the Court of Appeal dismissed Hawk's applications for leave to appeal against both his conviction and sentence. It concluded that the trial had been conducted fairly and in accordance with established legal principles. The hearsay evidence was properly admitted, the jury directions were adequate, and the sentence was proportionate to the seriousness of the offence. In Dutch courage, the deliberate act of consuming intoxicants to embolden oneself to commit a crime does not provide a defense, while in the case of AG from Northern Ireland against Gallagher, where the defendant intentionally drank whiskey to strengthen his resolve to kill his wife, Lord Denning ruled that a premeditated intention to kill, even if carried out while drunk, remains criminally liable. In the case of DPP against Majewski and DPP against Beard, the court ruled that mistakes resulting from voluntary intoxication cannot serve as a defense for a basic intent crimes. And lastly, in the case of R against Fotheringham, the defendant mistakenly believed consent was given for sexual intercourse while intoxicated. The court held that such a belief could not be deemed reasonable.
We will now move on to the intoxication law in Malaysia. Intoxication is provided as one of the general exceptions in the Malaysia's Penal Code. According to Section 86, Sub 3 of Penal Code, intoxication shall be deemed to include a state produced by narcotics or drugs. Section 85 of the Penal Code outlines the conditions under which intoxication may be considered a defense. Subsection 1 states that except as stated in this section and Section 86, intoxication does not serve as a defense against any criminal charges. Subsection 2 provides that intoxication is a defense to any criminal charge if by reason thereof the person charged at the time of the act or omission complained of did not know that such act or omission was wrong or did not know what he was doing. Subsection 2 para A provides that the state of intoxication must have not been self-induced in that the same was caused without his consent by malicious or negligent act of another party. If the intoxication was a result of one's own action, such as the case of overconsumption of alcohol, subsection 2 para B seems to suggest that in a case where intoxication was self-induced or self-caused, the person must have reached the state of insanity at the time of the act or omission. Section 86 of the Penal Code highlights the effect of defense of intoxication when established. If the defense sought falls within Section 85, sub 2 para A, then an accused person should be acquitted. On the other hand, if the defense sought falls within Section 85, sub 2 para B, then an accused person should be detained at the pleasure of the Yang di-Pertuan Agong YDPA, that is to say, the court should determine his insanity under Section 84 of Penal Code and read together with the provisions of the Criminal Procedure Code, Section 347 and 348. Subsection 2 clarifies that intoxication shall be taken into account for the purpose of determining whether the person charged had formed any intention, specific or otherwise, in the absence of which he would not be guilty of the offence. In the case of Public Prosecutor M. Muhammad Noriza bin Mat Tahar, when the respondent, clutching a Rambo knife, walked outside the prison's bachelor's barrack to approach the deceased, he told the key prosecution witness that he intended to kill the deceased. When the witness followed and caught up with the respondent, he discovered that the respondent was still holding the knife and that the deceased's shirt was covered in blood. He also overheard the deceased say, "Why did you stab me, Kuching?" The respondent was given the nickname Kuching. The respondent raised the defense of intoxication on the grounds that he had consumed a can of beer at the time of the incident. The federal court ruled that the evidence presented clearly demonstrated that the respondent voluntarily consumed a can of beer soon before the occurrence. Section 85 sub A of the Penal Code states that self-induced drunkenness is not a defense. Furthermore, in this immediate appeal, there was no scientific evidence to establish the respondent's intoxication, taking into account his actions before and after the offence. It was clear that the respondent understood what he was doing. The conviction and sentence given by the trial judge under Section 302 of the Penal Code are restored.
There are few similarities and differences between the defense of intoxication in Malaysia as well as in the United Kingdom. The first similarities is in both countries, mere intoxication does not exempt criminal responsibility. In Malaysia, under Section 85, Section 1 of the Penal Code, it's clearly stated that mere intoxication does not exempt a person from criminal responsibility. This similar principle is actually upheld in the UK case of Public Prosecutor against Majewski, which means that if an accused cannot present sufficient evidence for intoxication, they cannot exempt themselves from the criminal responsibility. In Malaysia, until now, there is no one single case who can successfully raise the defense of intoxication. This proves that mere evidence to prove intoxication is insufficient. The second similarity under the defense of intoxication in both countries is it requires a proof of unawareness. In Malaysia, under Section 85, subsection 2, paragraph B of the Penal Code, it's clearly stated that in order to raise the defense of intoxication, it must have the proof of lack of intent as well as unawareness of its action. This similar principle is upheld in the UK case of Beard, which they actually established a Beard test which requires the proof of lack of intent and unawareness of action as well. The third similarity, as explained by my two other teammates as well, is that both countries actually categorize their intoxication law into two categories, which are voluntary as well as involuntary intoxication. The last part is a distinction between the law of intoxication in United Kingdom as well as in Malaysia. The first distinction is the governing authority. In Malaysia, our defense of intoxication is governed by the Penal Code. However, in UK, it's solely based on cases and principles such as the case of Majeski, case of Weir, and other principles established by the courts of United Kingdom. Besides, in UK, they make a clear distinction between the law of intoxication for the specific intent offence as well as basic intent offence. Voluntary intoxication cannot be used as a defence for basic intent offences, but involuntary intoxication can be used by both offences. This is supported by the judgment in the case of Majeski. However, in Malaysia, we do not make any distinction between the basic intent offence as well as the specific intent offence.
In conclusion, the United Kingdom focuses on distinguishing between voluntary and involuntary intoxication and its impact on mens rea, while Malaysia incorporates stricter laws influenced by cultural values, especially regarding alcohol consumption. Both jurisdictions uphold the right to defense, but Malaysia imposes harsher penalties for offences under intoxication, whereas the United Kingdom emphasizes public safety and individual responsibility. The defense of intoxication involves case-specific considerations, societal values, and legal precedents, highlighting the interplay between justice principles and cultural influences in both countries.